This presentation will focus on whether or not English contract law should adopt a notion of good faith. In simple terms, good faith is the general presumption that parties will interact with each other and deal with each other honestly, fairly, and in good faith. It is important to note that there is no general doctrine of good faith in English contract law. This means that unless stated by the court, neither parties have the legal obligation to disclose their actions to the other party and do not have to abide by the idea that parties should not deceive each other. The only exceptions to this are where there is an express duty, when there is a contractual discretion and a term of good faith is implied, or when the agreement is a relational contract and there is a term of good faith implemented. However, the term that is implied depends on the express provision in question. In terms of the contract, there are a few conditions that must be met for a term of good faith to be implied. Firstly, it must not contradict the rest of the contract. The contract must not be acting in a way where good faith cannot be applied or would go against something in the contract, causing the contract to be void. It must be necessary to give off business efficacy to the contract, also known as intended power to produce results. For a duty of good faith to be implied, it must also be necessary that the original results that were required from the contract still are able to be produced by the end of the contract. It must be obvious that there is an implied duty of good faith, and it must be capable of clear expression. There must be a clear demonstration of good faith in the contract. In the Yam Seng contract, an express duty of good faith was implied, meaning that the part of the contract that depicted that it was necessary that both parties disclosed honest information with each other. The defendant, International Trade Court, breached this part of the contract by giving Yam Seng, the claimant, information that they knew was false. Therefore, the breach of the contract was repudiatory, serious. The defendant was asked to act in good faith, meaning any information disclosed must be honest, and they provided information that they knew was false. Courts have been traditionally viewed as being hesitant in respect of the terms of good faith. There are two overarching reasons on why this position is taken. First, good faith is said to undermine the predictability and outcome of certainty of how and can go against the ability to achieve and require the exact contractual performance. Secondly, even as an express term, does it amount to an agreement to agree? It is a question of whether the duty of good faith is within a contract means that the contract is still agreeable. Some difficulties can be seen in the instant that there may be very general terms of a contract. For example, a contract is to be formed with good faith or something similar where no further detail is provided. For these two reasons, I believe that where it is time for English law to embrace a duty of good faith in the performance of all contracts, the extent of what is required of both parties must be heavily detailed to avoid confusion and minimise the loopholes in the law. If a contract requires both parties to act in good faith, it must detail at which point they must act in good faith, such as when exchanging information or when forming the contract itself, to avoid any miscommunications or breaches of contract.